rural economic development, and that is a fantastic thing.
Thank you, Mr. Chair. I know your support for choice, so I appreciate your consideration. In an earlier contribution, Mr. Chair, I asked a question of the Minister and the Chair around the disputes resolution scheme. Having sensed a lack of appetite to answer that question, I've taken some time to inform myself of the disputes resolution scheme within the bill, which is good. But there is another question I do want to ask because of some wording in Schedule 2 of the bill, which inserts a new Schedule 3C into the original legislation. Clause 1 of that kind of outlines what the point of the disputes resolution scheme, which is to ensure that if two or more persons have a dispute in relation to the installation of fibre, they have access to the dispute resolution scheme for resolving their dispute. That's great. No one is going to think that this piece of legislation is going to think that everything is going to happen peacefully and that there will be disputes. But deep in Schedule 3C 2B says the resolution scheme provides for disputes to be assessed, quote, promptly after they are received for the purposes of any dispute. So my question, either to the Minister and the Chair or to the officials that have been looking after this piece of legislation, is what, in a bread and butter case of a dispute, when there is some kind of conflict, what does promptly mean? Because the point of putting this disputes resolution scheme in and bringing in some of the changes in the legislation here is to make things go faster, not just in terms of the broadband speed, but also in terms of the process to get the broadband installed either in a private dwelling or in a business. And if there is a dispute, I think the last thing that someone who's been waiting for a tremendously long time, waiting to get their broadband installed, is a delay if there is a dispute. So if the Minister and the Chair or one of the officials could give us an idea of what promptly means, that would be very, very useful. I want to tie this back to the case that I spoke about in my earlier contribution, and that is of a local business who was having a dispute with some of the other other businesses that are in the business. They were wanting to get some pretty fast broadband into their building, but I think there were some issues with getting access to common areas. The issue for that business is that they wanted to increase the size of their staff by a considerable number of people, but because there were delays, that really impinged on that company being able to do that. If that is going to happen, I think, and stymie growth and stymie job opportunities, I think a business or businesses or people out in the community would like to know what promptly means. Now, I know there'll be some extreme cases that might take months. It might, in fact, take years at one extreme. But if it's a simple case of access to or dispute over the amount of time that a provider might need to get access to some of these areas, I think it's not a bad question to ask how long the disputes resolution scheme might take to adjudicate on that. Will the disputes resolution scheme be able to weigh up all these issues? Is it fair that it's being held up with a complaint? If it is holding back businesses from being able to hire people and grow their business, is that a factor that is going to be taken into consideration by those people who are going through that complaints process? Because I don't think I'd like to see a local firm being held up in a resolution scheme process if it means 10 jobs being offered to people working in my community. I think that is not good progress. It kind of defeats the purpose of having a disputes resolution scheme, and especially if people who might be adjudicating thinking that some of those people who are holding up or complaining are doing it just to game the system. I think I'm not sure from the legislation, and I hope the Minister and the Chair might be able to elucidate this for us as to whether or not those kinds of factors will be taken into account, not just the physical factors of access to and time taken to install, but also other factors driving a business or a person wanting to have broadband put into their premises, and I quote, promptly, and what that promptly might mean in terms of dispute resolution scheme. Anyone?
The question is that the Minister's tabled amendment to clause 11 on SOP number 280 be agreed. Those that have that opinion will say aye. Contrary opinion will say no. The ayes have it. The question now is that the Minister's amendment set on SOP number 280 as amended be agreed. Those of that opinion will say aye. Contrary, no. The ayes have it. The question now is that Part 1 as amended stand part. Those of that opinion will say aye. Contrary opinion will say no. The ayes have it. The question now is that Part 2 stand part. Those of that opinion will say aye. Contrary opinion will say no. The ayes have it. The question now is that the Minister's amendments to Schedule 1 set out on SOP number 280 be agreed. Those of that opinion will say aye. Contrary opinion will say no. The ayes have it. The question is that Schedule 1 as amended stand part. Those of that opinion will say aye. The contrary opinion will say no. The ayes have it. The question now is that the Minister's amendment to Schedule 2 as set out on SOP number 280 be agreed. Those of that opinion will say aye. Contrary opinion will say no. The ayes have it. The question is that Schedule 2 as amended stand part. Those of that opinion will say aye. The contrary opinion will say no. The ayes have it. The question is that Clause 1 stand part. Those of that opinion will say aye. The contrary opinion will say no. The ayes have it. The question now is that the Minister's amendments to Clause 2 set out on SOP number 280 be agreed. Those of that opinion will say aye. Contrary opinion will say no. The question is that Clauses 2 as amended and 3 stand part. Those of that opinion will say aye. The contrary opinion will say no. I will report this bill with amendment presently. Members, we now turn to the Resource Legislation Amendment Bill. The bill is in 5 parts. Members will be aware that Part 1 amends the Resource Management Act 1991